Hello, YouTube. I'm Vince White. I'm an employment attorney. And today we have an email from a friend of the channel, David, who is back. It's very exciting to have David back. And his email reads like so. You've spoken of many different forms of protected activity in a recent video, all of which can lead to unlawful retaliation by employers. Pause. Quick note. For our purposes here today, protected activity, think of it as raising a complaint of discrimination in the workplace, raising a complaint of sexual harassment in the workplace, raising a complaint of like unpaid overtime, in certain situations, raising, whistleblowing. There's more. This is not an exhaustive list, but these are, the roughest, quick list of protected activities you can engage in. And when you engage in protected activity, what arises from that is, because it's protected, right, it arises protections, protections against retaliation. So it's a valuable thing to engage in because, one, you're doing the right thing. Two, you're gaining protections, and it can help protect your job. It can help keep you safe while you do the right thing. David continues. I'm wondering how often employment attorneys see claims of FMLA retaliation by employers. Also, if you can, will you outline for the viewers the several different forms of FMLA, several different forms which FMLA retaliation can take? Okay, so we're going to do that because it's interesting and it's valuable, I think, to the viewer. But here's a really simple test that I want you to apply if you're confused about this. And if you think you understand it perfectly, you're confused. Okay? Not to be a jerk about it, but like, people call up all the time. They're like, yeah. So X, Y, and Z happened, and now I'm owed $30 million. And you're like, I don't know if you read that right. We'll talk about it. Let's get to the bottom of this, right? So the test I want you to apply is, did you complain about something in the workplace? And as a result of your complaints, did something bad happen to you? Did you experience a negative workplace consequence? And if the answer is yes, then what I'm going to say to you is you should be contacting a local employment attorney, scheduling a free consultation, having a conversation, and seeing if they think there's a claim there that they can help you with. And honestly, ideally, you're talking to 2 to 3 local employment attorneys to get this answer, okay? So and I'll throw a note on top of that note. If you're calling up an employment attorney, a plaintiff side employment attorney who wants to charge you for a consultation, pump those brakes. That's probably not the person you need to be talking to in an industry where your case is an opportunity for us, right? Any given person that we're helping, right? If I spend 2 hours helping you and I find a case and that case is worth $5 million, well, that's an opportunity for me to win a big percentage of $5 million, right? So you ought to be getting in this industry to help people. And if you're rationally self-interested, you will help people, because in this industry, the only way that you should be making money is by helping people, right? That is, in fact, how we generally make our money. We help people. And as a result of helping people, we make money. And the more we help people, well, hopefully the more money we make. Right? So that's, both you have altruistic reasons why you should be doing these consultations for free, and you're just rationally self-interested. If you do these consultations for free, if you help people, you will find more claims that are valuable, that you can help with, that you can represent someone on, and hopefully win them money, right? So, be leery of paid consultations in this field, in my opinion. And, different jurisdictions are different. There's a very nice woman down in Georgia who likes to write me mean emails every time I say this. And say somewhat offensive things about how I shouldn't be talking about whether or not she should charge for consultations. As if I've ever named her or even knew who she was when I said it. But that being said, let's stop digressing and get back to David's email. So he has a list here of common forms of FMLA retaliation. Disciplinary action. If you have a write-up, if you got a bad review, if you got talking to, threatening, whatever it is, right? In your workplace because you took FMLA, or even if you just think it's because you took FMLA, right? I don't expect you to know. You're not psychic. You can't know what lives in the hearts and minds of your management, the people you work for, right? So there's a presumption. You just came back from FMLA recently, and all of a sudden they're giving you a really zany write-up that's not accurate, not fair. I feel like you can safely assume there's a good chance that might be retaliatory. Number 2, termination, right? If you come back from FMLA, or you're trying to take FMLA, or you're out on FMLA and you get terminated, there is, some correlation, some reason to believe that termination was motivated by your use of the Family Medical Leave Act, FMLA, right? So, that's a really good one. It's always a really good sign. The termination can make an FMLA case more valuable. It certainly raises the stakes, right? Next, he lists reinstatement to a lesser position or other assignment. And on this one, this is a great one. I love that he concluded this, because lesser should be viewed as a very broad term. If you come back from FMLA, or also the other one, I see this on all the time, is maternity leave, right? If you're out on maternity leave, or you're out in FMLA, and you come back and they give you a lower paid job, or they move you to a department with worse career prospects where people don't get promoted, or they move you to a department with much more onerous work, right? Like if you're a lab tech and they move you to cleaning out the toilets, right? You might not want to clean out the toilet. Listen, I clean toilets for a living. It's not a bad job. It can pay really great. You get to listen to music. It's pretty swell. I'm not, in any way speaking poorly about that job, but I am saying you, as a lab tech, may not want to do that job. You may view that job as more difficult, more onerous, and you may not want to do it, and that could be lesser, right? So when you're looking at what's a lesser position or not a lesser position, what I want you to do is apply kind of an eye of the beholder standard, right? How do you, as the employee, feel about the new position? Is it lesser? How is it lesser? And be ready to articulate why you feel it's lesser to the attorney you're speaking to, okay? Reduction in pay and benefits. So if you're being paid less, if your vacation time, your sick time, your insurance is going down, all these things, right? Reduction in pay and benefits can, of course, be a form of retaliation. Interfering or restricting or denying the use of FMLA time. So this certainly happens. Common issue. People trying to throw up red tape, people trying to dodge emails, people trying not to see you in person, people avoiding your calls so you can't, people not providing you the correct forms. There's all these things go on. You should be aware of that as well. And then I do enjoy, David has a little tagline here at the end of his email. HR folks, human resource folks, love to proudly profess, we're the people which they love to hate. But he goes on. But we like this one even better. Employment attorneys on the plaintiff's side are the HR of HR. Yeah, I mean, listen. If HR did its job, and I have great HR professionals in my family, right? I am related to HR professionals who are tremendous at their jobs. 2 of them that I can think of at the moment who are really, really, really talented, on top of things, really good at what they do. But if HR knew in general their job, if they did their job in general, I wouldn't have a job. I would be doing something else, right? Anybody have a traffic ticket? I'll negotiate your traffic ticket down, right? But luckily for me, sadly for the world, most HR professionals, they're asleep at the wheel. They're not doing a lot. They're not training. They're not on top of things. They're doing the bare minimum to scrape by, kind of not paying attention. And so they fail to help people. And in failing to help people, claims get bigger. Bad managers, bad company owners get away with things. Claims get bigger. Situation spirals. And because HR didn't do its job, which is always, remember, to protect the company, not to help you, that just sometimes by helping you, they protect the company. But because, when HR doesn't do its job, these cases get bigger, and employment attorneys, such as myself, get hired. So I hope that we did justice to David's email there. I think I kind of threw a lot of information there, more than perhaps he meant for me to include, but such is my rambling. If this was helpful, like and subscribe. It does help me to help more people just like you. And I will check the comments down below. If you have follow-up questions, if you have specifics, if you want to run a hypothetical, probably don't post your specific situation with identifying characteristics. Post it maybe instead as a hypothetical without identifying characteristics. That way we can talk about it, or I can tell you if you should be speaking with a local employment attorney. Okay? Take care, everybody.